Ladyship have that? Yes. And then if you look at paragraph 4, ESCOM abides the decision of this court in respect of the merits, and opposes the cost or the sort. That's another matter. And in 5.1, it says that the purpose of 5 is the purpose of the affidavit, and in 5.1, ESCOM seeks to place facts before this court explaining the basis upon which it terminated the applicant's employment. Now there's the answer to, that's the immediate employer. That's the immediate employer. And if your ladyship cares to go back to volume A, just to finally close this point off. And that is the letter of effective termination. Your ladyship finds it page 34. What you find in paragraph 3 is that this is the letter from ESCOM signed by the chair of the board to Mr. Molefe. And what paragraph 3 says, in giving effect to the directive of the Minister of Public Enterprise, the board has resolved to rescind the reinstatement agreement between you and ESCOM on 11 May 2017. As a consequence of which you are effective immediately no longer the group chief executive of ESCOM. Now there are 2 points to be made with that in that regard. First of all, if you rescind a reinstatement agreement, it's difficult to understand how that agreement, as the minister seems to contend, is simply a nullity, doesn't exist. It's there. And if at best for the minister that was some kind of it was necessary to reconstitute the employment, and whether that was illegal or not, we certainly would valid. We certainly challenge that. We say there was no re-employment. But what they do is they effectively terminate. And that's what they say. You are no longer the group chief executive. Now they could have used the term you are dismissed, it would have been the same thing. What else could it be? No longer the group chief executive. It's a dismissal. And you can only be dismissed, therefore, if you have a contract. You can't be dismissed if you're simply there and you're on some kind of specious basis which is undefined. ESCOM understood that it was in fact a contract which was existent, and so did the minister. So that is simply the point we wish to make. That it's not as easy as saying, lady, that the Molefe's employment has been terminated, and now it's simply about that he was his reinstatement agreement is what is the primary issue before your ladyship. No, it's not. The primary issue is whether there was a dismissal from the existing employment relationship. Lady, might I just make one further submission regarding the question of the on the intervention question, and our learned friends have taken you through the various authorities that they rely on. My learned juniors have alerted me recently to a judgment. I'm afraid it's not in our heads or in our list of authorities, but I can just give it to your ladyship because there's something interesting about it. It's once again the Democratic Alliance versus the South African Broadcasting Corporation. Your ladyship finds the reference 2016 volume 3 SA 468 judgment of the Western Cape, and it's His Lordship Mr. Justice Davis. Once I believe still judge, he was Judge President, I believe, of the day of some stage. And read to your ladyship an excerpt which in fact puts the intervention into context. And this is in paragraph 4, your ladyship will find it. And what His Lordship says is the following: it might have been expected by the designers of the Constitution, who had laid out an intricate set of rules dealing with Parliament, that the official opposition in Parliament would have viewed the latter institution as the preferable location for disputing this appointment. I just pause to interpose that your ladyship will know that this concerned the unlamented Mr. Motsuneng, who was suspended and has ultimately now had his employment terminated. His Lordship goes on and he says the following, but he says lawfare, the use of law as a replacement for political warfare has become commonplace in South Africa. Now, in our submission, this is what is happening. It's happening in this court. The DA and the EFF do not have an interest in the employment. They have an interest in the High Court litigation. We accept that, and Mr. Molefe fully intends to oppose that. But what they're using is they're using the courts to fight what is essentially a political battle. They're using this court, I'm correct myself, their right to a review that they will argue before the High Court in due course. But it doesn't mean that they can now bustle in and seek to raise what is essentially the same arguments in this court they're going to argue in the other court, where there's no danger of that later court saying, well, the Labour Court has made a substantive finding on it. No danger of that perspective. So it is lawfare. And these matters of protecting principles, proper governance of ESCOM, we accept that, but that happens in the High Court, not here. Now, the lady, as far just on some points on the particular question of joinder, which we then deal with in our heads from page 7 and onwards. We've heard from our learned friends for the EFF in some detail the questions of the public, or the issue of the public protector's state of capture report. Now, my learned friend said to your ladyship that these allegations are undisputed. He's not right. And we need to correct that. Mr. Molefe has taken the position in the High Court, which is similarly the position in this court, that those allegations are in fact disputed. And I just want to give your ladyship the references to that. 586, which we find in volume, I believe it is E, lady. Your ladyship, the references I don't need to read. Mr. Molefe, I just noticed that. So 586, my lady, paragraphs 20 goes on to the following page, and then 574, that was 568, I'm sorry, I didn't relate to the wrong words. 568 is paragraph 14.4, going over to 569, and then 574, paragraph 53.3. He refutes those allegations. It's not correct to say that those allegations are unchallenged. But more importantly, the submission is made to your ladyship that this court must now consider whether Mr. Molefe is a suitable person to be employed at ESCOM. Now, in respect to our learned friends for the EFF, that's a remarkable proposition. There's a contract of employment between ESCOM and Mr. Molefe, primarily with the Minister as a party.
It's not for his court to decide.
In respect to contracts, which is not true. Lady, what we've said in our submissions under this joinder, this question, it's a personal right, and it's supported by the judgment of His Lordship Mr. Justice Wagley, present Judge President. We give your ladyship the reference in footnote 24 on page 8. The reference is Martins and others versus SA National Parks. It's a judgment in persona. It's only valid between the parties. Of course, this is a state-owned entity, but it doesn't alter the effect of it. It's not a judgment in rem. Judgment in rem is one, and His Lordship makes that distinction quite clearly. Judgment in rem is one which is binding on the world. This contract doesn't bind the world. It binds him, it binds ESCOM, and the Minister to the extent that she is. Now, turning briefly, Molefe, to the reinstatement agreement. The argument, just to round that off, is that the reinstatement agreement is a hotly disputed issue before the High Court. We agree with that. It is indeed. It's not an issue before this court. We'll be able to demonstrate, confidently we can demonstrate to your ladyship that there's no break in the termination. That's our view, it's our submission, it's our version before your ladyship, Mr. Molefe's, and it's a version of Eskom, and it's a version of the minister before she does her most remarkable about face. So that's the issue before your ladyship. And to try now to force that issue into this court can only be part of, the aim can only be to try to have this application pushed out to another court. And we've made the submission. In that court we have so far got the DA, we've got the EFF, we've got Eskom, we've got the minister. Now what we have is we have the prospect, and we make the point in our heads, of a further joinder by Solidarity, who has joined 21 parties, including the former Minister of Finance and various other parties, the public protector. Now, just consider that. How does one possibly ask Mr. Molefe to bring his dismissal application to that? That case, if it's heard this year, will only be by a miracle. It won't be heard this year. So that's what they want to do. They want to achieve that. And they want to argue that before your ladyship. That's the purpose. They've got their day in court. They're not prevented from having their day in court. We want to be there to meet them on that. And we can only meet them if we still in court. We need that employment. Otherwise, we may as well give up on it. Now, lady, as far as this res judicata, we deal with this in paragraph, page 11 and following. The principles are set out on paragraph 29 of our heads. If I could just pause briefly on that. The common law requirements, we haven't heard any difference from our friends on this. The same parties. Maybe on that particular point, there's somewhat of a sleight of hand here, because it can never be before this court, absent an order joining the political parties. They're not parties. So a judgment that issues in this court between Molefe, Eskom, and the minister does not in fact impact upon the law. So they fail at that first hurdle. It's not the same party. They fail whether it's res judicata or whether it's issue style. The second requirement, really, is the same cause of action. Now, what your ladyship knows from having read these papers is this is a dismissal case. Mr. Molefe asks for an order setting aside that termination, which will effectively permit him to continue his employment. It's a common law matter. There's been a breach of the contract. He says he does not accept that it's repudiation, and he insists on the contract being honored. Now that one contrasts with the very strong public law, administrative law, and constitutional law basis for the High Court applications. That is a matter where, and it's a classical review which is brought there. It brings in all of those elements, and the EFF particularly brings in the constitutional elements. So the cause of action here is not the same. So judgment, once again, any judgment that issues from this court doesn't impact, it doesn't prevent that review from happening. And added to this is the third requirement, that it is the same relief. We want a setting aside of that dismissal. Now what the parties in the VA wants in the High Court is to set aside the board decision. That's not administrative law. The decision is a matter which is governed by party. So they want to set aside the decision to reinstate Mr. Molefe. And what the EFF wants is a declaration that that actions on the part of Eskom and the Minister was contrary to Section 195 of the Constitution. And they also want an order to dismiss the ESCOM board. Your Ladyship will find that, just for convenience, in the founding papers, it's annexures 2A and 2B. I'll just give your Ladyship reference to that. 2A commences at bundle A, page 35, and the page 41 is 2B, that's the EFF. The Ladyship will find, when I talk about the relief, I talk about obviously the Part B relief, the final relief. So, on any basis, this cannot be grounds, and we haven't heard from our learned friends in their principal arguments what great harm they will suffer. And then, Lady, if we can take you to a judgment which we referred to in our heads of argument. And Lady, I forgot to mention, we had in fact it's my fault, great energy, colleagues have prepared a bundle of authorities, just maybe convenient. Might I hand that to your Ladyship? This is a Canadian judgment, but it may be easier if your Ladyship were to look at that. Sorry, I just want to get for our learned friends. If I could take you, it's right in the beginning, it's the judgment of the High Court of Australia, and the Ladyship finds it commencing at page 1. If I could ask you to turn to page 11 of the paginated volume. This is partly a quotation we've done in our heads, but I just want to add a further point to it. What His Lordship says there at the very foot, the final paragraph on page 11, there's another point to be noticed. Issue estoppel applies only to issues. There is no estoppel as to evidentiary facts found in the course of determining the affirmative or negative of the issue. There's nothing to prevent a party from tendering in later proceedings in relation to a particular fact's negative in earlier proceedings when they were tendered in relation to a different issue. Now, can we just take that particular proposition and apply it to the present case? This complaint about the effect of a ruling by, judgment by your Ladyship, which somehow touches on the reinstatement agreement. As was indicated, Lady, that's not an issue. But if your Ladyship were to say, for example, that on balance and on spectus of the facts, there was an employment relationship which existed as of the 2nd of June 2017, at which point Mr. Molefe was dismissed from employment. The Ladyship doesn't need and would not, with respect in the circumstances, make a positive finding as to the reinstatement agreement. We submit that the evidence would be sufficient to persuade your Ladyship that, in fact, it was. So if that is then the judgment, and its judgment issues, the order of issues is that the dismissal is set aside. Now that in no way hampers or restricts the DA or the EFF from arguing before the High Court in a review that will in fact cover wide-ranging issues, as our learned friends of the DA say in their written submissions. They can in fact reserve that position and they can argue that. And there's nothing with respect inconceivable or irregular with this court reinstating Mr. Molefe on on the basis of an unlawful dismissal, only for the High Court subsequently to decide on a different basis, a different course of action, that the very basis of this employment is in fact impugnable as a matter of administrative law. Nothing whatsoever. What we submit before you on that score is that if we take the situation that existed as at the time when the DA and the EFF launched the applications, mid-May 2017, Mr. Molefe was employed. If this court reinstates Mr. Molefe, that is the position which will confront them when they come to the review court. No different. That then comes, and that is fundamental with respect to this question of intervention. And that is why we submit to your ladyship that there should be no intervention. They will have their day in court. They're not hampered, they're not restricted, and they can still argue that Mr. Molefe should not be employed on all of the grounds, including the public protector's report. That is therefore. Lady, the final topic, very briefly, and I'm not going to belabor this, is the question, the suggestion, and it's once again not suggesting that our learned friends have abandoned the point, but it wasn't pressed before you in argument. The question of the allegation that Mr. Molefe is forum shopping. It's a rather nice buzzword, perhaps overused. And what your ladyship finds.
I think the argument on that would go with the main forum shopping or the peaceful approach taken by the that are
My understanding is that it's part of this application, and if I'm wrong in that regard, well then I don't need to deal with that. Just perhaps we'll check with the friends.
We'll deal with it in the main application, if we're allowed to be heard.
I agree with Mr. Kennedy.
It will go with the main if you are allowed that you know the main.
Indeed, my lady.
That was my understanding.
I'm obliged to your ladyship and to my friends. Lady, I won't then deal with that. What I would like to deal with briefly is some of the points that were just raised in argument, so that I miss anything. Yes, our learned friends for the DA argued that there was something odd about the failure to challenge the locus standi in the High Court. Well, what we've done in lady is we've opposed that relief. And once you are a respondent, when you oppose the application brought on the basis of local standi, when you oppose it on the merits, or both, you're opposing it. We are Mr. Molefe, and that's perhaps something which has not been properly focused on. Mr. Molefe is a respondent in those proceedings. So, what is his options? He can bring an in limine argument to say knock out the local standi. I think that we all know in this court that there are no prospects of that succeeding. Courts do not entertain it. That's peaceful. So what you do is you oppose it. You oppose it on the proper basis. second point is made is that learned friends, particularly for the DA, but also for the EFF, say that there is not only an inextricable link between this application and those in the High Court, but also that Mr. Molefe concedes that. We refer in relationship to pages 6 and 7 of the founding papers, which they say justifies that attention. Well, in respect, that's not so, because if we look at what Mr. Molefe says in this regard, he says, of course, the relief overlaps to an extent, but more importantly, what he says on page 7, paragraph 10, is he says that Part A of the resolution, DA seeks interim relief interdicting from receiving any benefits, performing the duties. And he says in paragraph 11 that Part A is set down for Tuesday, the 4th of June, bearing in mind, ladies, that this affidavit was proposed to on the 3rd of June.
That was prior to the agreement that was.
As you please. Absolutely. Absolutely. So, and this, of course, two points that come out of this. Of course, there's a link. The link lies in the urgency. That's why he had to come to it. So what he says in his founding papers is he says exactly the submissions that we've made before your ladyship, that if he is not reinstated and the application on the 6th of June proceeds in the High Court, well, then he has no opposition to offer. The application, that his defense is moot. And that, of course, his opposition to that High Court relief is premised upon him being in employment. So that's where the urgency comes from. There's not much said. The urgency is, as I understand it, the matter which will be dealt with in the main application. But that's the link. And of course, the link lies in the urgency. That's where the link lies. It's not that Mr. Molefe has in any way conceded. You cannot read his affidavits like in that way, that this is a matter that should in fact be dealt with before the High Court. I learned a friend for the DA very fairly says in his argument that whether his defense in the High Court would be rendered nugatory is debatable. We say it goes beyond debatable. We say that there's no basis in which you can go and oppose. They can't oppose that. Is there any contention that the submission was made before your ladyship that I learned friends to the DA, that the DA and the EFF, they have a right to continue with the High Court litigation, and Mr. Molefe somehow wants to influence that right. Well, we dealt with that partially, but quite contrary to that, it's an inversion of, in fact, that submission. What the DA and the EFF seek to do is to prevent that offence in that application from, in fact, being DA say that the application is not frivolous. We accept that. But what we do say, lady, is that it's tactical. It's tactical in order to achieve a result, what we call the bloodless victory, so not in time. Very briefly on the submissions by our learned friends for the EFF, they seem to focus almost exclusively on the merits. I don't want to traverse that. I we ask for respectful submission. Those are matters which probably will be debated before those parties who are parties on Thursday. What we are, the submission is made that some contracts have a public law duties and obligations. Absolutely right. It's absolutely right. For example, contracts concluded by ESCOM for suppliers certainly have a public law. They also have a private law element. And this is contract of employment, which is predominantly private law matter. The entity itself is a state entity. Molefe is an employee of a state-owned entity. He's not, neither the state nor is he the entity. That is a private law matter. Ladyship is told that Mrs. Molefe is not entitled to the benefit of an illegal contract. Well, what your ladyship knows from these papers is that the minister is taking exactly that position. So how that is improved by the DA and the EFFB here, this is particularly a submission by the DA, is in fact not immediately apparent. The question of Mr. Molefe becoming a minister of the National Assembly, that's a matter of public record. And the submission there seems to be that that means automatically that his employment terminated. No, it doesn't mean that. That is a matter, if he has in fact breached the Constitution, which says that he's not entitled to serve as a member of that National Assembly as well as his employment contract continued throughout, then that's a matter for the National Assembly. It's a matter for them to take. It's not a matter, it's not a reason to say that he is not in fact employed. If you ladies should give me a moment to confirm. Lady, those are our principal submissions. We ask for the order that we pray for dismissing the application for leave to intervene. We see that everyone has asked for it. Certainly the DA has asked for it. Plus the 3 council, we asked similarly for the plus the 3 council.